Assalamualaikum and hi everyone. My name is Muhammad Imran Shah bin Abdul Razak and my metric number is 207648. I will be presenting about the decision of the court according to Korea Wallpaper as the plaintiff and Pendaftar Cap Dagangan as the defendant. Okay, as we all know about the case, the plaintiff was rejected twice by the defendant regarding the trademark application. Appeals to High Court under written laws where an appeal lies from any decision of any person or body or of person to the High Court. Such appeal shall be made to the High Court instead, where the decision was given by way of an originating summons, setting out the grounds of the appeal and supported by an affidavit. And if the court so directs at the hearing of the appeal, by way of oral evidence. The appellant shall annex the following document to be filed in the appeal proceedings, such as the first one is notes of evidence, if available, recorded wholly or partly by mechanical means, and second, the grounds of decision, if available, and the third one, the decision of the statutory body, and fourth, all such documentary exhibits and other documents the party shall consider relevant for the purposes of appeal. And to simply put, this appeal is basically a review of the defendant's decision as gleaned from the grounds. Okay. The attainment of actual or factual distinctiveness is a question of fact that has to be established by way of cogent evidence of years of use and business in respect of the circulation of the product bearing the mark and public identification with it readily. In this respect, the court noted that the application was made by the plaintiff on 31 October 2012. Consequently, the plaintiff must necessarily prove years of use and business which resulted in the public associating the mark with the plaintiff's product prior thereto. As a matter of fact, the plaintiff only changed its corporate name to Korea Wallpaper Sendirian Berhad on 7 June 2012 from its original name of Prima Habitat Sendirian Berhad that was incorporated on 6 November 2009. It is uncertain as to when the plaintiff actually commenced its wallpaper business. There is no evidence adduced by the plaintiff as to its wallpaper product sold bearing the mark between 2009 and 2012. The plaintiff only referred and relied on the article in respect of a press interview by Sinchu Daily that was published on 19 October 2011, which featured the plaintiff's marketing director, Albert Chu Lisin. This article is comprehensible because it has been exhibited in the plaintiff's supporting affidavit only in its original content in the Chinese language without translation in breach of the rules of court 2012. It is entirely unhelpful. And as to the plaintiff's other supporting documents, which were all post-2012 and as submitted by the defendant, the court find that they related more to the plaintiff's company as well as its subsidiary company, Center of Design, Excellence Sendirian Berhad, and called as CDE rather than the mark. It can be discerned that the plaintiff imported wallpapers primarily from two Korean companies, Shinahan Wall Coverings Company and Cosmos Wallpaper Company. These wallpapers were, however, thereafter sold by CDE to customers. The court noticed that the mark only appeared coincidentally in their publicity signage and business documentation, such as CDE's taxes invoices. And be that as it may, and more pertinently, the court find and hold that the supporting documents adduced by the plaintiff are inadequate to connect the mark with the general public, including consumers of the plaintiff's product. They are principally self-serving documents which merely highlighted the plaintiff's or more accurately, CDE's corporate successes and achievements that may have nothing to do with the mark whatsoever. And there is, in other words, no cogent evidence that supports the plaintiff's claim of public association of its product with the mark. The court had expected to see the findings of a detailed market survey by an independent researcher and the statistical result that connect the uninformed public and the plaintiff's product via the mark. In this regard, the derivation of a strong statistical correlation obtained from the survey is necessary to justify and conclude that there is indeed factual distinctiveness in the mark. As the result, the court finds that the plaintiff has, in the circumstances, failed to prove actual or factual distinctiveness in the mark too. Hence, the plaintiff has not succeeded in establishing the registrability of the mark pursuant to section 10(1)(e) of the TMA. So, for completeness, and although unargued by the plaintiff, the court have reviewed the findings and conclusion of the defendant in the grounds in respect of the inapplicability of the other provisions of section 10(1)(a) to D of the TMA pertaining to the registrability of the mark, and the court also satisfied that there is no appealable error on the part of the defendant. Okay. And for the foregoing reasons, this appeal is therefore dismissed by the court with cost of 4,000. That's all from me. Thank you.